She wouldn't let me go down and get it yet. I'll go get it when we take a break.
This is case number 13H320, the People versus Robert Bashara. Mr. Bashara is here today for a special pre-trial.
Appearances for the record.
Good afternoon, Your Honor. Lisa Lindsay on behalf of the state of Michigan.
Mark. Your Honor, Robert Moran, Assistant Prosecutor.
Mark Hindley on behalf of Your Honor.
Mark, proceed on behalf of Mr. Bashara.
Nancy Shell appearing on behalf of Mr. Bashara.
Okay, very good. Listen, how are you doing, Mr. Bashara?
Good afternoon, Your Honor.
Very good. Good afternoon, you also. What I want to do, there's some preliminary matters I want to deal with. I understand that there is going to be a request that will be made by Mr. Bashara. However, I will not take that at this time. Is that okay?
Yeah, I didn't hear you. You said you did not
I
take
said
it.
just wait.
Oh, okay.
Okay, just have a seat then.
That's fine, ma'am.
All right, have a seat. Everybody have a seat.
Okay.
The purpose of the court having today's hearing was to make a record regarding the search warrant that was signed by Judge Hathaway, and then there was some evidence that was taken, and then there was a special master, Judge Stepien, that was assigned to this matter to review the information. There's a motion outstanding by Mr. Henry Shard in regard to Mr. Dean Valenti, who he is representing today. So I want to deal with that first, okay? Basically, Mr. Bashir is not really even a party to this. So let me do this. There was a memo that was filed regarding this matter. So with the people, well, where's Mr. Valenti? Is he present?
Yes, he is, Your Honor. He's seated.
Okay, well, just have Mr. Bashir just sit over here. Could we just put him in the box? Mr. Bashir, we'll be back with you shortly.
Thank you, ma'am.
Don't worry about it. Don't take them far now. Okay, very good. Mr. Shard, Mr. Valenti, please come on. Okay, very good. Appearances for the record on this matter.
Again, Your Honor, Appellate Court, Robert Moran, Assistant Prosecutor, along with Lisa Lindsay and Mark Hindley.
Good afternoon, Your Honor. Henry Shard appearing on behalf of Dean Valenti. Can I put a few things on the record before we get going?
I gotta wait till Madam Clerk calls the case,
Okay,
and
very good.
she's not. Very good, thank you. Okay.
In the matter of Dean Valenti.
Okay, very good. Mr. Shard?
Just a couple things. First of all, multiple prosecutors on this case. Usually you have one prosecutor speak for the people in terms of an issue. And last.
Excuse me? What I want to do is this. If there are any witnesses, there are numerous people coming in here. I think that they may be associated with the media. But if they're going to, okay. If there are going to be any witnesses regarding this matter, I want them to step outside. There are two gentlemen in the back. I don't know who they are. You related to this matter? Yeah. No, if you're not going to be a witness and don't step out, you're fine. You don't have to identify yourself. All right, very good. Okay, go ahead. I'm listening, Mr. Shard. Thank you, sir. I'm sorry about interrupting you. I just didn't want any impropriety. Go ahead.
Right, and I think it was appropriate for you to say that at this time.
Sir.
Except that, you know, usually on issues before the court, you have one party for each side. And last time I was getting double teamed. Although I can take it, it's procedurally you have one person arguing for the prosecution on this, and we don't need double teaming three or four people who are on the prosecution team. So can we have one person designated who's going to be making the arguments and doing the hearing today?
You know, I'm going to just say this to you. You know, this case, you know, everybody's been telling me from the prosecution to the defense that this is a very unique and complex case. I agree with you. I have never seen multiple pleadings from the initial pleading was from Mr. Henderline. Then I get a memorandum of law authored by Pat Muscat that was hand-delivered to my court on February 14th at 3 o'clock in the afternoon. He's not here.
Yeah.
So, basically, who's going to argue this? Mr. Henderline, are you going to do it, or Mr. Moran?
I'm prepared to argue the memorandum that was prepared with Mr. Muscat, Your Honor.
Okay, very good.
Okay, and several procedural things. First of all, I also got this memorandum late on Friday. I was not aware that a transcript had been ordered, although I see snippets of that in the file, and I had no notice that in fact the transcript had been ordered, and I didn't have a chance to obtain a copy because the courts were closed yesterday. More importantly, though, is I've made numerous requests for a copy of the affidavit from the search warrant at my client's home, and the response has been continuously that it's under seal. Well, that's another unusual circumstance. We're talking about a case that's so old, it was supposed to go to trial within the next month, and there's a sealed affidavit, and based upon the statute, an affidavit is supposed to be sealed for 56 days, and after that period of time, that the prosecutor's office can seal it for additional time. I never got a copy of anything that it was sealed, and in fact, I'm prepared to argue today, but I think that I wonder why my requests to have it unsealed have gone ignored, and in fact why it still has to be sealed if in fact we're talking, you know, that's at the core of the issues here is the search warrant affidavit.
Let me understand this, and I'm going to get back to that momentarily. When was this affidavit sealed?
Oh, Your Honor, the affidavit was sealed at the time the warrant was presented to the circuit judge to review the search warrant.
And that date was?
That date was in October, I have it in front of me, just one second. October 20-something, Your Honor, of last year.
No, of 2012.
That's last year, 2012. This is, no, 2013.
2013.
Yes.
All right, go ahead, I'm listening. For the memorandum, go ahead, sure. I'm going to deal with this memorandum, and I'm going to deal with those issues.
If I may address Mr. Sharg's issues first, because he talked about a couple of things that need to be addressed prior to going to the memorandum, if that's okay with the court.
That's fine.
He first indicates that we're double and triple teaming him, but the unfortunate reality is, Your Honor, is that given the shortness in our staff, we are spread thin. I've been in trial for last month. Mr. Hindelang was here. He was in trial with me, and he was also here at times. Ms. Lindsay has other matters to be here on. And the unfortunate reality is that, yeah, it would be nice if just one person or two people could handle this case, but because we have other obligations in this office, that's just not physically possible at this time to do so. As it relates to the memorandum of law that was presented to the court last week, this is really a sum and substance of an email that was sent out probably a month ago by Mr. Hindelang, which laid out the law and the facts, and it's just a summary of that, plugging in the transcript references from the last two court proceedings that we had. So Mr. Sharg had that in his email at least 3 weeks ago. So he's not really in a position to claim surprise by the memorandum. We just wanted to put our position clearly on the record.
And this is what is so unique and it's difficult. That's not what the court rule requires. You know, all of this emailing back to various parties, at some point in time, you know, that's just not acceptable. Mr. Sharg has indicated, and the court rules require that there be personal service, that there is going to be motions that are going to be made. But this atmosphere of emailing, and then Mr. Sharg says, well, you know what, I don't have notice of what's going on. That's what happens when it's not properly done.
I agree with the court, and part of the problem that we have, Your Honor, is that we're at a loss because we didn't ask for this hearing, and we didn't file a motion in this case. The court on its own set this hearing sua sponte.
Right. And this is what, you know, I saw the two cases that were presented and cited, and the court wants to talk about MCR 6.201 when it talks about disclosure of privileged information. MCR 6.2012C says, regardless of whether the court determines that the record should be made available to defense, the court shall make findings sufficient to facilitate a meaningful appellate review. Now, what we have here are incidences that have not gone recorded. There has been a presentation of a search warrant to a circuit court judge while this case was pending before me, which you deal with in a memorandum as investigation. Then there is an appointment by a trial court judge to a master without the trial court that's presiding over it, without my permission or knowledge. There is no order in that file that judge ordered the master to even prepare a report. So how would there be an opportunity to make a finding sufficient to facilitate a meaning appellate review when there are no orders?
Judge, I think
when there is no record. And please, if there's transcripts of the proceedings that you went before Judge Hathaway, I didn't get them.
Judge, I think the court is talking about Michigan Court Rule 6.201, and that's the discovery aspect of once a criminal case is filed. When we have a discovery, a criminal case pending.
But it deals with privilege,
I understand
information
but
being turned over, and that's my understanding, that we have to make a determination as to the information and whether or not there's an attorney-client privilege in regard to what was seized by the search warrant.
Yeah, but we're way ahead of ourselves, Judge, when we're talking about 6.201, because we're not even at that point. Mr. Valente and Mr. Shark have not been charged with anything criminally. There's no criminal case pending. That rule does not apply. That may apply to Mr. Bashara if at some point in the future any of this evidence that was seized we seek to introduce. But we're not even at that point yet, Your Honor. So we're not even at the point of making a record that relates to I think it was, what was it?
But
C
my understanding,
2A.
6.201C, but my understanding is that the evidence that was taken, that the reason that the master reviewed it is there was a determination that she wants to turn it over to the prosecutor's office so you can use it in your case in chief?
I don't know. I have not seen the master's report. The reason the master was appointed, Your Honor, is because the unusual nature of the search warrant. When we do a search warrant on an attorney's office to seize materials that may be part of a criminal investigation, we were seeking to protect not only the defendant's rights but also the rights of the attorney by not having that information tabulated, by not having it reviewed by the police officers, by having it sealed, having it preserved, and then agreeing to the procedure of having a master appointed to evaluate the evidence to see if there's anything there that's remotely relevant to our criminal case. So those efforts were agreed to by us to protect not only Mr. Valente.
Agreed to by whom?
By the
Between
people,
yourselves?
but the people of the state of Michigan and Mr. Shard representing Mr. Valente.
Mr. Shard is shaking his head. Is
That's
that
not,
correct?
that's not, I'll respond because that's not totally accurate.
But go ahead.
Well,
And see, that's where we are. And this is what's frustrating to me. Because we're not dealing in orders, we're at a position where Mr. Shard says, no, I didn't say that. And there may have been an understanding. Per my review of some of the emails, Mr. Shard was a willing participant.
Correct.
But I can't then incorporate that to anything because it was not taken in a courtroom. It was just what I believe it to be. And that's my problem with how everything is going. I want everything now to be, unfortunately, by testimony, by order, because I don't want someone to be able to come back later and say, well, that wasn't my understanding.
well, Judge, part of the problem that we're having is that the court doesn't really have jurisdiction over this issue. The court is the trial court, and the court has jurisdiction over trial issues of witnesses, issues of evidence, issues of motions. But when we're dealing with something that we're still investigating, the court...
Wait a minute, hold on for a minute. You're still investigating. We're 5,000 page documents into the investigation of Mr. Bashir. He's been charged.
Correct.
And you're still investigating.
That's our obligation, Your Honor. As prosecutors, we have an obligation to continue the investigation even after someone is charged. We do that
You do that when?
all the time. We do it in every case. If we have a murder case and the defendant comes forward and says, I have alibi witnesses, we have an obligation to go out and look at them. DNA evidence comes in, we have an obligation not to ignore it, but to continue the investigation. And sometimes during the course of a case, even after an arraignment, there are search warrants. There are other issues that have to be examined, and my point is that that's investigative. That's an investigation. That has
That's
nothing
your
to do.
determination.
Correct. That's our problem.
And here's the situation. These search warrants predated, as I understand, the charging of Mr. Bashir,
Some search warrants predated and some postdated.
as it related to Mr. Valente. Is that correct?
I think the search warrants were in October of last year, Your Honor. That was after.
No, that's why we don't have it. Do you have a search warrant?
Do I have the search warrant? Not on me, but I can get I can get the search warrant. I can get a copy of the search warrant. It was in October, I'm told, of 2013.
Okay. And so, but the request from the information that was contained in the search warrant came back in March and May. Is that correct? There was some information on a
Right.
cell phone, I mean, not on a cell phone, but on
Jail
on
calls.
a jail phone.
Right.
That occurred back in March or May of 2013. That was the basis of the search warrant being executed in October.
That was
Is that
part.
my understanding?
That was part of the basis, Your Honor. To be accurate, that was only part of the basis. There was
Okay, now
additional
Mr.
information.
Bashara got charged in,
April, I think, of 2013,
okay,
and then
so we know at least some of this is in regards to Mr. Valente predated that. Is that correct?
yes.
Okay. And then this information, some 5 or 6 months old, can you tell me how it was that you took that information and you waited that long to get a search warrant?
Judge, I can tell you that based on all the investigation that we were doing, at that time, we had an affidavit that was prepared by the affiant, presented to the circuit judge, and the circuit judge found probable cause. And in that affidavit, which I believe is 10 or 11 pages long.
And I'm just kind of curious, is there not a requirement that circuit judge that you arbitrarily went to make an order appointing that master, or
Judge,
not?
first of all, I take an issue with the court's determination of arbitrary. We went to the presiding judge of the criminal division and were directed to go by the presiding judge to Judge Hathaway as his alternate. So it wasn't arbitrary on our part. We followed the same procedure that we followed in every other search warrant, in this case, taking it to the presiding judge. And the presiding judge is the one who directed us to go to Michael Hathaway.
Oh, okay. And that was despite the case being assigned to me?
That's correct, because
Okay.
there's no court rule, there's no law, there's no statute, there's no constitutional provision that says that post-AOI search warrants have to go to the trial court. In fact, according to the case that we found, there's strong evidence to suggest the opposite, that it's a good reason not to take search warrants to the judge as assigned to the trial, because the judge would be reviewing evidence that may not be admitted at trial. And then two problems. One, they might then have to rule on evidence, suppression of evidence that they authorize to be seized. And two, if they make a determination in trial, they may be making determinations based on facts that are not in evidence. And so the better practice is not for trial judges to sit and review search warrants on investigations that continue after arraignment.
Well, you know what was interesting is that in your brief, the Genesee prosecutor versus Genesee Circuit Court judge, that particular case was after the arraignment. That was a charge that was made, and the judge decided arbitrarily to take a plea to a lesser charge. But what's interesting, and the court had an opportunity to look at, was the Figer versus Cox case, in which it talked about the people, the Attorney General, going and getting search warrants from a district court judge, and how the plaintiff in that manner, Mr. Figer, then arbitrarily went to a circuit court judge under the guise of asking for superintendent control to get the district court judge to state any further action of the district court and to preclude any further search warrants. And the Court of Appeals said that that type of action on behalf of them, instead the circuit court exceeded its authority and then improperly rewarded plaintiffs' forum shopping, first by wrongfully taking the case, and secondly by improperly interfering with the legitimate and proper investigation by the Attorney General. I'm not saying that you don't have a right to do further investigation. That would be preposterous.
Right.
What I am saying, however, that I do believe that it would have been appropriate for this court to know that this matter was taken to another judge as part of this investigation when the case was assigned to me.
Judge, I understand the court's concern, but there simply is no law, there's no rule, there's no precedent, there's nothing that says that the trial court has to be notified that we continue to investigate a case.
Moreover, let me just say this, and in that case it says that basically that what the plaintiff did, although there was no law on point, like what you say, the participation of a circuit court judge to thwart a legitimate felony investigation through technical gamemanship involving our judicial system. So basically it's this. Well, it's not a statute that requires you to know. So therefore we opted to not do that because we wanted to protect you. However, it's so ironic because there were witness detainers that were brought to me on this matter.
Yes, Judge, but that witness detainer is different than a search warrant. And just to follow up on the point.
I'm just saying, why wasn't I given the information that another circuit court judge was signing search warrant and appointing masters to determine the admissibility or the legality of information that was seized from Mr. Valenti's house?
Can I ask the court a question? How would I do that? How would I notify it?
First of all, I think that it would have been incumbent upon the people to have come before this court and let me make the determination, first of all, that for the reasons that you've stated, that it may be improper for me to sign the search warrant and then to seek some type of assistance either from the circuit presiding court or from my alternate, which is normally done. That's normally done, because that's why we have alternates.
Okay.
Then, I think what would have been appropriate is after that judge signed that search warrant, that I then had been requested to have an interview with the prosecution as well as the defense to then appoint a master that I believed would be capable to go through that information and then give me the report so that I could review it in camera to make a determination of its admissibility. That's what I think the procedure should have been.
So, Judge, what you're saying to us is that we should come to you and tell you ex parte that we're continuing an investigation.
No, I
and we
think
should have
that,
ex
no,
parte
excuse
communication.
me.
Judge,
Go ahead, I'm sorry.
Judge, we can't come to you. You are the trial judge,
Okay.
and you represent the arbiter of the people versus the defendant. And if we're continuing our investigation and we want to have a search warrant, what you're saying is we should come to you and say, Judge, we want to do a search warrant on some property that we may
Okay.
admit against him,
Okay.
but we can't do that with this court.
Listen, this is what I'll do. I'll agree. I agree with you. But once that search warrant was executed and those documents were obtained, then it was your responsibility to say, now we got something, Judge, that we got another judge to do, and we need your help. We need your help to appoint a master to make a determination. The master is going to determine, A, is there a privilege in this particular information?
So you're agreeing with us that we can't come to this trial judge
Possibly.
for search warrants because that would be ex parte.
Yeah, but that possibly.
And so that's
I'll
improper.
concede that.
Okay, so there's the procedure that was followed for the execution of the search warrant, all the things that we did. Previously, the court had said we were forum shopping. Previously, the court had accused us of going around this
And
court.
you know what?
Judge, may I finish?
No, and let me just say this to you. I'm woman enough to retract it and say I was wrong.
Okay.
Okay, now, I was wrong. I'll concede that. But now that the information, you've been in Mr. Valenti's house, and you got all this stuff out, why wasn't I then informed, hey, we got some evidence, and we need some help? Why wasn't I informed about that?
Again, Judge, because we don't know what that evidence is, and we're not there yet. We're not at the point of where this is even going to come in against Mr. Bashara. This is a court order signed by a co-equal judge. Judge Hathaway is a co-equal judge to this court. He signed the order. It's his jurisdiction on that case. He's the one who had the meeting with us, with the defense, with Mr. Shar. He's the one who appointed the master.
But why?
Because he's the one who signed the search warrant. He's the one who authorized the law enforcement to go execute that search warrant and
If-
seize the evidence.
If the search warrant were signed by him because you brought it to me, and I said, I think it's in the best interest to have either my alternate or to have the presiding judge to sign the search warrant, then that portion would have been delegated to somebody else, but then the ultimate decision, once this information was retrieved and the master that should have been put on that case, the court believes should have been in my purview at that point, because it was during the case was before me.
Again, Your Honor.
And I
think-
disagree.
Okay, and I think your disagreement is
And-
properly levied to Judge Hathaway, not to us.
What-
Because Judge Hathaway is the one who appointed the master. Judge Hathaway is the
But-
one who had the meeting with us and said, I'm going to appoint a master to review the documents and then get a report and make a determination.
But wait a minute, first of all, isn't it the responsibility for the prosecution, the court, to be forthcoming so that the defense has an opportunity to address anything that has occurred? And see, that's what's going, this is gamemanship. And this is the part that I don't like about what happened in this particular case. Well, should the court really take that up with Judge Hathaway? No.
Judge, I mean,
No,
with
I
all-
don't think so.
Okay, with all due
Because
respect, though, for
here's the situation. There is no record. There is no record. Is there a record of the search warrant?
Yes, there's an affidavit, there's a search warrant that's been
Okay.
authorized by the judge and signed,
When
right?
Mr. Shard was present, when there was discussion about the master being appointed, was there a record made?
I don't know. I was
You
present.
don't know?
I don't know if it was on the record. I'm not sure if notes were taken. I'm not sure. Judge, but here's the problem I have.
So
is that-
how is there appropriate appellate review of Mr. Hathaway or Judge Hathaway's decision, of what you said or what he said? There's no record.
Judge-
And so what happens is, and when there is no record, it falls upon each side to say what they believe occurred at that particular hearing.
Correct, but Judge, there's no basis for a record. There's no basis for judicial intervention at all. Because you're way ahead of, the court's way ahead of itself on this issue. Because there's no reason to have.
Well, let me ask this question. If there was not a need for judicial intervention, then why did Judge Hathaway appoint a master?
When I say judicial intervention, I mean the trial judge's intervention. Because there's no evidence yet that we're seeking to admit in this case, the case that's before you. We are not at this point ready to say we want to admit these 3 items, these 4 items, these 15 items that were taken pursuant to the search warrant against the defendant. So that's what this court's jurisdiction is. This court's jurisdiction is the people of the state of Michigan versus Mr. Bashara, not Mr. Valente. Mr. Valente's house was searched by a court order that was signed by a judge of co-equal jurisdiction. And the problem I have with this court is that, first of all, you accuse us of being unethical by saying that we're forum shopping. Second of all, you enter an order saying that we cannot get search warrants in this case without your authority. Then you say we can't issue subpoenas without your authority, without your approval. And now you're saying we're playing games when we agree to a procedure to protect this person's rights and have a meeting with a circuit judge where we agree to a master and agree the documents be sealed and not be examined by police officers, and the court says we're playing games?
But wait a minute. You don't have a record of that, do you?
Judge, there was a meeting with a circuit judge with
Well, Mr.
7 or 8
Shard
lawyers.
is shaking his head.
He was
And it's-
there, Judge. He was at the meeting.
That's right, I was.
And he-
Can I get a chance?
And he agreed to the procedures that we followed, and everyone agreed, and then the master was appointed, and those proceedings were advancing.
But just like the court says in the Figer case, the proper thing to do is appeal. If you disagree, if you say, Judge, you don't have the right to say that we can't issue investigative subpoenas, appeal me. Don't go to another judge of co-equal jurisdiction.
Judge, we've never
Judge,
Judge, we've never done that. We have never sought to overrule you. We've never gone around you. You accuse us of doing that time again, but we've never done that. We didn't come to you and you deny a search warrant or deny us an order, and then we go to a judge of co-equal jurisdiction and go around you. That would be improper. We've never done that.
No, I wasn't given the opportunity.
And nor are you required to be given the opportunity. There's no law, no court rule, no statute, no ordinance, nothing that requires us to bring a search warrant to the judge whose the case is assigned to. In fact, the evidence suggests that's not a good idea to do that.
Okay, and that case is?
There,
that says that the trial judge should not be presented with a search warrant?
There are a number of cases, Your Honor, that talk about how it's not a good idea
Okay,
for a
and
trial
they are-
judge. We referenced one, I believe, in our brief. There's other cases that are not from the state of Michigan.
I looked up the ones that were in your brief. The only ones that I got on this memorandum were Genesee Prosecutor versus Genesee Circuit Court, 386 Miss 672, Feiger versus Cox, 274 Mishap 449.
Right.
That's all I got.
Okay.
Now,
And
maybe
it-
I didn't get the other part.
And did any of those cases say that we're required to bring a search warrant to this court? No. Did any of those cite a court rule? No.
Well,
The
first of
statute?
all,
No.
they're factually distinguishable because the Feiger case dealt with an investigation before the defendant was even charged.
Correct.
The Genesee County case dealt with a plea-taking procedure by which a judge took a plea to a lesser offense. So technically speaking, none of these cases are on point anyway, factually. They all have the same verbiage that it is in the purview of the executive branch as
Correct.
investigating, as a prosecutor, to be the sole investigator of the county. Basically, that's all it's stating.
Correct,
But
but-
these cases are not factually on point.
Judge, they are on point because they say that the court does not have jurisdiction
But
over
they're
us.
factually,
the
not,
law- The law is clear that the circuit court does not have superintendent control over the prosecutor. We have the right to investigate our case. The court cannot tell us how to do that, when to do that.
I agree with that.
And there's
But
no- and there's no-
Once these formal charges were made against Bashara, in all fairness, the court believes that I should have been made aware of
Okay.
what was going on.
First of all,
and that's
Judge-
it. I'm not going to hear any more.
But
I
Judge,
don't want
wait,
to hear from
but Judge,
you.
no, Judge,
Wait a minute. No, I don't. No.
May I finish the record? May I make a record at least?
Okay, go ahead. And then I want to hear from Mr. Sharp.
There's no rule or law that says that.
Okay.
I'm sorry if we offended you, but if we offended you, I apologize. But we can't do that because that would be ex parte communications, Judge. We can't come to you and say, we want to execute a search warrant on some property that may yield evidence against Mr. Bashara and tell you what that is without co-counsel being there because you are the trier of fact in this case.
Okay.
And so if we did that, that would be ex parte communication. That would be entirely improper.
Okay, very good. Mr. Sharp.
I can't believe what I'm hearing and how not only are they stepping over each other, but Mr. Moran, who I respect, stepping over himself today for the simple reason is ex parte, and that they don't want you to be tainted. The prosecutor gave you a copy of the search warrant affidavit to review. So if they didn't want you to get tainted by knowing anything about the search warrant, why did they give it to you in the first place? Last month. Their whole argument defies logic. In terms of this case, they're still investigating. Mr. Bashara was doing, I believe, maybe 15 years in prison on another case while they're investigating. There's no statute of limitations. They had free reign to investigate this case as long as they wanted to and complete, connect all the dots and do everything they needed to do before they charged him with this offense. He's sitting in prison for 15 years. There's no statute of limitations, and yet they're saying weeks before this, I guess, a scheduled trial in this matter, they're still investigating. It's mind-boggling that the Dream Team, and the last time I saw 4 lawyers on the same case was in the OJ case, why they need 4 lawyers to do a homicide case, when in federal court they're doing death penalty cases with 1 or 2 U.S. attorneys, I guess, who are experienced to handle things. But more importantly, ex parte, in federal court and in other circuit courts around this state, what the prosecution could have done, and they should have done, was file ex parte, under seal, a document to the court, at least advising the court of what's going on in this case, and at no point in time did they do so. The only time you found out about this case was that when I'm playing games with the prosecution and trying to get back my client's
No,
records.
you're wrong. Let me interrupt you.
I sent it. No, I sent it to CC.
Excuse me. No, the first time I heard about it was at a dinner party from the master.
Okay.
But go ahead.
Well, before she was appointed, and we're circulating these emails and negotiations, and I said, why isn't Judge Evans involved in this conversation? And so there's the first email is I emailed the others and said, why isn't Judge Evans participating in this? Why don't we have her involved? I had no idea what's going on in this case. I came in only, at a late point to get Mr. Valente's records back. I don't know, they're the ones that, the prosecution are the ones that should be held accountable because they know exactly what they were doing in this case. They know when they were seeking judges to sign affidavits, they knew all these things. And I come in because my client's home office is raided. We're trying to get back his files, and then I hear for the first time that they haven't done an inventory at the house. They've just sealed everything and took it down to the prosecutor's office. So there's a conversation that it's Judge Hathaway signed the affidavit. I didn't know the history of this case, so we agreed to go to Judge Hathaway because I don't know anything. And then all of a sudden, it's Judge Hathaway that appoints the master. And again, is my understanding was they even excluded Mr. Bashara's lawyers from Judge Hathaway excluded Bashara's lawyers from any of this conversation. So they weren't even able to review the documents which were possible work product or privileged or whatever. The bottom line is that this is just a big mess. As the court said, this is the first time I heard about Judge Kenney recusing himself was in their response the other day in this memo that Mr. Muscat. I had no idea what was going on until that point. The problem is, as the court said, this is just. Just going back to the core, and I'll sit down, we're talking about the prosecutor's office obtaining a subpoena and a search warrant, one in the left hand, one in the right hand, and going into an attorney's house office and raiding that office, and which is done rarely, and it has to be done with very conscious and cognizant understanding of what we're dealing with.
Well, here, look, I'm going to say this to you. We've done enough. We've been over this road enough, okay? And we made a record. Good, bad, and different, we made a record. What I do want to do, I understand your position, both of your positions, I know, okay? And at this point, I don't want to make it appear that I am accusing the prosecutor's office of anything. I know the prosecutor's office is working very, very hard in this case as well as other cases under a handicap because there's not enough people that are in this office to do the type of job that I believe that the leadership of Kim Worthy would want to see. Okay, number one. So I understand with Mr. Valente, we're here today to get to the bottom of all of this. There's going to be a record made. That record can be reviewed, and whatever happens in this case, learned or graded minds make a decision. But what I want to do today is I want to be able to make a record as to what occurred as far as there was I think that, I'm not going over a search warrant, but I believe that there was one that was signed. I just need to know the testimony of what was taken. Then there was a master who was appointed, so that after there is a record that is made, then I can make a determination as to what the proper orders are to be to go forward from here. In that there needs to be a proper order done, preserving this evidence as well as ordering the master to review it in a timely fashion and giving this court an opportunity if there is evidence that is not privileged to, or is not work product, to make an in-camera inspection. So that's what we're here today to do today. I don't want to hear any more argument. Your positions are noted. Okay. Can attorneys approach? Not on Mr. Bashara. Okay, where's Mr. White? Is he present?
I believe he's sequestered, Your Honor. I'll get him.
All right, so raise your right hand. Do you solemnly swear affirm testimony about to give this man the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do, ma'am.
Please. State your name for the record.
Brian White.
Pull the microphone up. Okay.
Brian White.
Do you want me to proceed, Your
Yes,
Honor?
Brian White.
Okay.
I got you.
Brian White, you're a detective with the Wayne County Prosecutor's Office, is that correct?
Yes, I am.
In fact, you're the Deputy Chief of the Wayne County Investigative Bureau, is that right?
Yes, I am.
How long have you been a detective?
12 years.
And back in October of this year, did you,
October 29, 2013.
of 2013, did you prepare an affidavit for some evidence to be seized from Dean Valente?
Yes, I did.
And with every affidavit that you prepare, is that pursuant to the request for a search warrant?
Yes, I did.
And in order to get a search warrant signed, you know you have to take it to a circuit judge or a district court judge, is that right?
Yes, I do.
Now, in this case, in the case of the people of the state of Michigan versus Mr. Bashara, have you been taking all the search warrants to one judge in particular?
Yes, I have.
And which judge is that?
That's Judge Timothy Kenny.
How many search warrants, just approximately, have you taken to Judge Timothy Kenny?
I'm on a rough estimate, maybe about 70.
Okay. And back in October of 2013, when you prepared this particular search warrant, did you follow your ordinary course of taking that to Judge Kenny?
Yes, I did.
And did Judge Kenny tell you to take it to someone else?
Yes, he did.
And did you do that?
Yes, I did.
Okay. And the other judge, was that Judge Michael Hathaway?
Yes, it was.
And that was at Judge Kenny's direction, correct?
Yes,
Okay.
that's his alternate.
Now, after Judge
You
Hathaway,
don't know that, do you? You just know that he said to take it to someone else. Is that correct?
did Judge Kenny tell you something?
Yes,
What did he
he's
tell you?
told me before to take it to his alternate, which is Judge Michael Hathaway.
And did you do that?
Yes, I did.
And did Judge Hathaway review the affidavit?
Yes, he did.
And did Judge Hathaway, in your presence, sign the search
Can
warrant?
attorneys approach?
Do you want us all or just me and Mr. Moran?
Yeah, just a minute. Oh, no, yeah, okay. Yeah.
Can I have Lisa too? She's my lawyer.
You may need one after this is over. Come on.
Any more?
Come on down. Okay, good, go ahead. All right, go ahead, I'm sorry. Maybe I just, I'm sorry. Okay, thanks. Go ahead, sir.
So after you went to Judge Hathaway, you indicate he reviewed the affidavit?
Yes, he did.
And did he swear you in and authorize the issuance of that search warrant?
Yes, he did.
Now, that search warrant affidavit was sealed, is that correct?
Yes, it is.
And that was also pursuant to your practice?
Yes.
Okay. And the tabulation was also to be sealed, correct?
Yes, it is.
Now, when you went to execute the search warrant at Mr. Valente's home, did you also have a subpoena?
Yes, I did.
And were you directed to have a subpoena by attorneys from the Wayne County Prosecutor's Office?
Yes.
And were you directed to first attempt to serve the subpoena on Mr. Valente?
Yes.
Okay. And did you go to the home?
Yes.
And did you attempt to serve the subpoena?
Yes, I did.
And what happened when you attempted to serve the subpoena?
When I handed the subpoena to Attorney Dean Valente, he said that he reviewed it and he said he could not comply with it because it would be considered attorney-client privilege.
Okay. And then after he refused the subpoena, did you then present him with the search warrant?
Yes, I did.
And were you present during the execution of that search warrant?
Yes, I was.
Now, at someone's direction from the Wayne County Prosecutor's Office, was any and all items taken from Mr. Valente's home, were they sealed?
Yes.
And did you follow directions from an assistant prosecutor to do that?
Yes.
And were those documents sealed into a box?
Yes.
And in fact, several boxes, correct?
Yes.
And they weren't even inventoried, were they?
No.
Okay, they were sealed.
Sealed. Yeah.
And why were you directed to seal that material?
Because we weren't sure. We wanted to make sure that nothing would violate the attorney-client privilege that we had taken up from the house.
Okay. And once the material was sealed, where was it taken?
To the Grosse Pointe Park Police Department.
And was it placed on evidence but sealed?
Yes.
And is it your testimony, Detective White, that no one examined that evidence to your knowledge?
None.
It was sealed? Okay.
Yes.
I have nothing else.
Detective White, you've been in law enforcement for how many years?
26.
And you were with the Wayne County Prosecutor, with the Wayne County Sheriff's Department?
Yes.
And you retired?
No, I'm still currently active.
Okay, you're on leave, you're assigned to the Wayne County Prosecutor's Office, is that
Yes.
correct?
Yes.
But you're still employed by the Wayne County Sheriff's Department, is that correct?
No, I am a Wayne County Prosecutor's Office employee.
Okay.
It's
I'll
a
move on.
difficult way to explain it.
There's no need to.
But you're not moonlighting, are you?
No, nothing like that, no. No.
Now, you've been actively involved as an investigator for the prosecutor's office on the Bashara case
Yes,
for some period of time?
yes,
For how long?
basically since its inception.
Okay. And when was that? Month or
Probably
year?
February of 12.
Okay. Now, you testified that on October 29th, is it October 29th of 2013, is that when the search warrant was signed?
I believe that the search warrant was signed on the 28th and executed on the 29th.
All right,
And that's
so,
October.
Yes,
All right, so-
October of 2013.
okay, so I'm going to digress for a little while. So the search warrant was presented to a magistrate judge on October 28th, is that correct?
Yes,
And was executed the following day?
yes,
Okay. You also mentioned, you testified, that there had been a subpoena for documents and records of Mr.
Yes.
Valente.
I'm sorry, yes.
Okay, when was that subpoena prepared?
I can't remember when exactly it was prepared offhand.
Would you agree with me that it was prepared several weeks before the search warrant was requested?
I'd have to see the document.
Do you have it available?
Me? No, I do not.
Well,
We gotta take, can we, is there some way that we can get this document?
can we stipulate?
We don't have it, that's right.
Judge, just real quick, is that was a key issue, last time we were here, was the fact that there was a subpoena and search warrant.
Wait a minute, just wait. Is there a possibility if we take a recess, you could go get a copy?
I'm not even sure if I still have a copy of that. I'd have to go look at my records.
You don't have any documentation. Is there some way that we can get that from a typist? Excuse me,
I know where it is.
where is it?
When they executed the search warrant, they served Mr. Valente with the subpoena, and they took the subpoena back and they put it in the other documents that they seized from his house. So that's where we saw it.
So you
When
don't
we
have a
reviewed.
copy, you don't believe you made a copy of the subpoena?
I don't think I did. I think I had one copy.
One copy?
I believe so. If I'm trying to remember from recollection what exactly, if I had one or two or...
It's incredible, because if you serve a subpoena, you give the subpoena to the individual, so you would have to keep, you give a copy to the person, so you have to have the original to have it filed or some type of...
Well, we
This is,
understand
wait,
that.
this is interesting, but I object, this is not relevant, because the search warrant was executed, the subpoena was not authorized, was not honored.
All right.
So it's irrelevant.
It's not irrelevant, because in fact, what we were saying, and the reason for our motion for return of the property was that they were armed with a subpoena, that they could have presented to him, and normally, like what is done, you give someone an opportunity to present, to produce the documents, especially when they're so sensitive as an attorney's files with work product and confidential materials. So what happened? So what we're saying happened is that they prepared a subpoena 2 weeks prior to the search warrant.
Would you stipulate to that?
No, I don't have a copy of the search.
They do have it. It's in their office.
Judge, I think it's in, where Mr. White, or Mr. Sharp said, it's probably in the box. with the
Is the
materials.
box president in the building?
It's on lockdown, but we don't have access to it, it's sealed.
No, I don't think that's a sealed document.
Well, I haven't gone through the
It's-
Is
materials.
there some way that you can go back and check your office and see?
I could look, yeah.
But Judge, why is this relevant? Because Mr. Valente refused the subpoena. He refused to honor the
Well, we
subpoena.
don't know that that is the case.
It doesn't-
That's his testimony.
That's fine, but I'm saying it was never honored, and so as a result of his refusal, the search warrant was presented. He could have said, okay, I'll comply with the subpoena, then we'd be talking about a subpoena, but we're talking about a search warrant,
Sure.
a court order, because he refused to comply with it.
Well, that completely contradicts their argument, because if they had a subpoena that was prepared 2 weeks earlier, and they sit on that subpoena, and they bring it with the search warrant, and there was no intention at all of subpoenaing the documents, but only conducting a search warrant, the date of the search, of the subpoena, who signed it, who prepared it, is relevant in this proceeding.
I
Maybe,
do agree, because I think the argument that counsel is making is that there was not an opportunity given to Mr. Valente to comply with the subpoena, and that as a result, he gave him the subpoena and a search warrant, which is highly problematic. This is what I'm gonna do. Let's take a 10-minute recess. Can you go up to your office and see if you can find it?
I can try,
Okay,
yes.
that's all we can do. Thank you. Can attorneys approach?